Take on Civil Law from Renee Doss. In August 1997, Mr. and Mrs. Melchior found out they were going to bring a baby boy into the world, and now I'm going to explain why the parents weren't so ecstatic at first. And here's a rundown on the events. Carrie Melchior wanted to stop taking birth control, so she decided to get her fallopian tube sterilised. In the process, Dr. Cadenac had previous records that her right fallopian tube had been removed when she was 15. He failed to look further into the state of her right fallopian tube, or tell her if he had only performed the surgery on one fallopian tube with another existing, that there was a risk that she might conceive. Mrs. Melchior then gave birth to a healthy baby boy. Then the couple claimed compensation from Dr. Cadenac for the cost of raising and maintaining the child until he's 18, for loss and damage caused by pregnancy and birth. The plaintiffs were Mr. and Mrs. Melchior, while the defendants were Dr. Cadenac and the State of Queensland. The case was heard in the High Court of Australia. Here's some legal basis and relevant information. The first case was in 2000. There were 3 claims: medical negligence, negligence via damages, and negligence of standard duty and care. Mr. and Mrs. Melchior have a right to choose the size of their family. A quote from the case is, "This being the case, the parents were entitled to recover damages for the economic consequences of the established physical events caused by the negligence." The second defendant, the State of Queensland, admits liability for any negligence on the part of Dr. Cadenac, who was engaged as a consultant obstetrician and gynecologist at the Redland Hospital where the procedure took place, although it denies that there was any such negligence. Here's some evidence that I brought up in the case. Some points from Dr. Cadenac's personal account were: with sterilisation, there was still a 1 in 300 rate of failure, and it would be ectopic, meaning birth via C-section. Dr. Cadenac gave evidence that he had taken a history from Mrs. Melchior of the removal of her right ovarian tube with the apectomy 24 years ago. It was his usual practice at the time to draw a diagram to illustrate the procedure so the patients can understand clearly. He could not recall Mrs. Melchior asking for a cut-and-tie operation, but if she had done so, he would have explained to her that it would be a more serious operation requiring a longer recovery time. Here's some points from Mrs. Melchior's personal account. Mrs. Melchior had said she had requested sterilisation by cut and cauterizine, cut and tie, although Dr. Cadenac had recollection of making a joke about the fact that one of the Filshie clips, which comes in sets of 2, would be wasted. So wouldn't Mrs. Melchior have said something? She'd seen him 2 minutes before going into the operating theatre to undergo the sterilisation surgery when he asked her to sign a document. Although Dr. Cadenac says he did not recall seeing Mrs. Melchior before her surgery, she denied that she made any mention of her right fallopian tube during their appointments. How did the evidence help the judge or jury? Their personal accounts assisted the judge with their verdict by putting pieces of what happened together and helped make sense of both their opinions. The verdict was the parents of a child born as a result of the doctor's negligence were entitled to recover the damages for costs of raising a child until adulthood. I agree with the verdict because Dr. Cadenac was at fault, because he blindly operated off documents from 25 years before the surgery, and he should have checked the state of both her ovaries and fallopian tubes before doing anything serious. The main reasons given for this decision was because Mrs. Melchior came to Dr. Cadenac in seek of help from someone who's entrusted to care for the public, but instead he overlooked one area and resulted in Mrs. Melchior being disadvantaged.